Thank you all. We would like to start our second panel discussion of today. So we will talk in this panel session about the impact of new technologies, including also artificial intelligence, on justice and legal practice. I have the privilege to moderate this session, and before introducing our excellent panelists, I would like to also set the scene a little bit with sharing also some thoughts on this. I think we have all noticed really a considerable surge of technology in our daily lives over the last years. With the COVID-19 pandemic, we all got used to doing things online, but also even to an extent probably we never imagined before. And although we already knew for several years that also AI computing was coming to us, and we saw it already starting to influence our lives through our phones, the rapid rise of generative AI tools such as ChatGPT over the last year has brought more to the forefront really the immense potential of this technology and the impact of this in various sectors, and of course also the legal sector will not be excluded from that. So before we knew this was happening, now we feel that it is happening. And AI and digitalization more in general, they will bring fundamental changes to our justice system as well by automating routine tasks, providing data-driven insights and even predictions, accelerating case law analysis, document review, etc. So these are obviously promising advancements. But we are also starting to see better and better that these things also give rise to complex ethical issues. And when looking forward to integrating AI in also the justice system, we need to, of course, start paying very careful attention to these elements as well. And this brings us then to the title of this panel, which invites us a critical exploration of the impact or the relation between, on the one hand, the emerging technologies and the values, the fundamental values and principles underpinning a legal system. And the question is then, is a match between both possible? As we witness the emergence of economic or algorithm-driven economies and even algorithm-influenced democracies, I think we have seen that as well. We have to question ourselves to what extent we would desire a development of an algorithm-based justice system. I will leave this question hanging in the air and first introduce our three panelists who are each driving force in navigating this evolving landscape of justice and in the digital age. Firstly, it's a great honor to welcome Marija Pejčinović Burić, Secretary General of the Council of Europe. Marija's previous roles have included being Deputy Prime Minister of Croatia and Minister of Foreign and European Affairs. And she oversees currently the Council of Europe's Action Plan on Digitalization for a Better Justice for 2022-2025. And her leadership and insights have been instrumental also in ensuring that Europe adapts and thrives in the face of technological advancements, while also upholding fundamental principles of human rights. Next, we have Nils Behrndt, Deputy Director General of the European Commission Director General for Justice and Consumers. And while Nils is in charge of criminal justice, he is also in charge of developing European consumer policy. He has a profound background in law and public administration that adds depth also to his work in navigating the challenges and opportunities presented by the digital era. And I can say that I was also recently at an event in Madrid where Nils was also presenting the Commission's program in the context of justice systems in times of change. And it's a real pleasure to have you here with us today. And last but not least, I'm delighted to also welcome to you CCBE Vice President Thierry Wickers. who has demonstrated exceptional leadership in the legal profession. He has been involved in the CCBE since 2012 and has chaired the CCBE committees on the future of the legal profession and legal services, as well as he worked on Brexit, statutes review, quality of legal services, and he further held positions as president of the Bordeaux Court of Appeal Bar Council, chaired the Conférence des Bâtonniers and the Conseil National de Barreau. So a very big welcome to you as well. So may I ask Marija, please, to first take the floor.
Thank you, Chair, ladies and gentlemen. It's really great pleasure to mark this year's European Day of Justice with you. This annual day was a joint initiative between the Council of Europe and the European Union, and I'm very proud of that. I also am proud to be here at the CCBE, a very, very important conference, since I happened to meet during the 4 years now of my tenure in office as Secretary General, leaders of the CCBE, and we were speaking about different aspects, not so much about EA at the beginning, but more about the legal professions, and especially profession of lawyers and bars, and what Council of Europe can do to advance this. And I think we are on the right way to do some things, and I will come back later to that. But thank you very much for this invitation, very timely. Although, you know, sometimes when seeing the rapid development of the AI, one thinks whether we would be ever so rapid as the development of AI is by its very, very nature. But I think this shows of pertinence and importance of talking and discussing the issues that are at hand and that will and are already influencing very much what we do on different levels on these issues. So this annual day actually aims to bring justice closer to European citizens by promoting our work in this field on their behalf. And central to this, of course, is our support for the legal profession, as I was mentioning, including our determination that bar associations and individual lawyers are free to do their work, upholding the rule of law without prejudice, fear, or favor. And the sentiment that underpins the 2021 Memorandum of Understanding signed by the Council of Europe and the CCBE, ici présente, Madame la Présidente, je crois.
Madam President was with us when we signed this memorandum.
Really very, very pleased that we already at that time foresaw the need for more mutually beneficial work on this. So it has helped us to work more closely together, addressing the emerging problems that face the legal profession and finding effective solutions. So new technologies are, of course, such a challenge. And let me say up front that these technologies must align with our core values. Because when we speak about the human rights standards protected and promoted by the Council of Europe, alignment is not only a moral imperative, but also a legal requirement. So the question is not if, but rather how. Underlining this debate is widespread concern about the rapid rise of artificial intelligence, and people are right to be concerned. AI is in the process of transforming the ways in which we live and work, and the public services on which we rely. So the transformation brings with it many potential benefits, greater speed, accuracy, and efficiency, for example, but it also raises a range of ethical questions that must be addressed. The impact on the legal profession is no exception. So yes, AI promises to make aspects of the administration of justice faster and more effective. For example, AI-led judicial decisions making is likely in civil, commercial, and administrative matters, where it can help to improve the predictability of the law and the consistency of the court decisions. But there are also risks. Article 6 of the European Convention on Human Rights guarantees in law the right of every individual to a fair trial. So how can we prevent bias, discrimination and mistakes arising from the use of AI, particularly in criminal law, and where these happen, who should be held responsible and what should be the remedy? These and other questions must be addressed, and work is already underway. The Council of Europe, European Commission for Efficiency of Justice, CCBE in French, en français, has produced a European ethical charter on the use of AI in judicial systems and their environment. This lays out 5 fundamental principles that member states should apply: respect for fundamental rights, non-discrimination, quality and security, transparency, impartiality and fairness, and an under-user control starting point. These are important, but we also understand the need for specific tools developed with the input of professionals and experts in the field. That is why the CCBE is an observer to the work of CCBE working groups, where, for example, it has contributed to the Resource Center on Cyber Justice and AI. Similarly, it is making a vital contribution to our Committee of Experts on the protection of lawyers, whose ongoing work on a new instrument will take account of the emerging use of the new technologies, notably AI, and their impact on lawyers. The broader aim of that instrument will be the protection of the profession of the lawyer, given the range of challenges it now faces, and this should be drafted by the end of the next year. Outre les outils sectoriels,
apart from the sectoral tools, we're also developing a new cross-cutting framework on the development, design, and the use of AI, so that AI systems comply during their entire life cycle with European standards in terms of human rights, democracy, and rule of law. Ongoing negotiations on this treaty include our member states and the European Union. However, they go far beyond our continent. Canada, the US, Mexico, Israel, and Japan have also contributed to this. And recently, we were happy to welcome Argentina, Costa Rica, Peru, and Uruguay. And this really demonstrates the global potential of a new international treaty, which will apply to the use of AI by law practitioners and to the whole of society. European leaders have approved our approach, including the Reykjavik Declaration, which was adopted in May during our Head of States and Government Summit. A draft text was published during the summer, and the final text should be published by the spring in light of the ongoing negotiations with the states, the private sector, civil society, and other international organizations. This is the path we have to follow. We're convinced of this. And this conviction has been drawn from our past successes. The goal is to guarantee the compliance of new technologies with our fundamental values. And here we're talking about specific tools which can be directly used by law practitioners. For example, in 2021, the CPEG provided guidelines for the member states about legal proceedings. And on the digitalization of legal cases and the digitalization of courts. Our Committee of Ministers has issued its own guidelines on the online mechanisms to for administrative and legal procedures so that they are in line with the European Human Rights Convention, especially with the right to a fair trial and to the right to an effective remedy before a court of law, and with the case law of the European Court of Human Rights. More generally speaking, we also demonstrated our ability to draft international conventions which protect the rights of individuals in times where technology are evolving very rapidly. On the topic of data protection, Convention 108 of the Council of Europe and its recent updated version, the Convention 108 Plus, are the only treaties which have a general, multilateral and binding scope on data protection and the protection of privacy. The Article 8 of the European Convention of Human Rights on privacy ensure that governments, when they use personal data, respect the principles of legitimacy, necessity, and proportionality. Convention 108 Plus is focused on the challenges brought about by the digital world, and it provides a basis for a transfer of data which complies with privacy. On the topic of cybercrime, the Budapest Convention is also a reference treaty in this field. It includes measures that were developed to help national authorities to prevent infringements, to protect their victims, and to prosecute the perpetrators. And on this basis, its second additional protocol was opened for signing last May, and it focuses on the difficulties linked to obtaining electronic evidence among jurisdictions. And thanks to this protocol, cross-border cooperation when it comes to collecting electronic evidence will be rendered easier and more efficient, and it will be endowed with systems providing guarantees. Once operational, it will help justice operate in the cyberspace. And I'm very much looking forward to this. As such, we could say that this is a rapid evolution of technology and our collective success in the application of our values, fundamental values. These standards affect human rights, democracy, and the rule of law. And they were developed so that they could be applied to all aspects of life on our continent. But beyond that, they were designed to apply to our partners as well. Political will is necessary so that new instruments can be prepared and applied. The will is there. Furthermore, we need to make use of this as we have done by the past, and we need to ensure that AI respects our rights, our values, and our interests in a way that is beneficial to us and to everyone else. Thank you very much, and I look forward to hearing your comments and questions.
Thank you very much. Thank you very much for this very comprehensive overview of the very extensive work that the Council of Europe has been doing in this field, and also in a very proactive manner. It is for us comforting to hear that you also made very clear that AI must comply with fundamental rights and core values, and that is not a question, but it's an absolute need and must. However, of course, it is always difficult how this can be really achieved in practice. And we know that the European Commission is also doing a lot of activities. And we are therefore pleased to see what you are doing. Please, Nils, the floor is yours.
Thanks a lot, Chair. Good morning, ladies and gentlemen. First, I would like to thank you for dedicating part of your event today to the question of digitalization and justice systems. The digitalization is taking up speed so much, it's changing fundamentally the way how we live, how our economies work, how our political systems operate, but even the justice systems that normally are strongholds against change, even the justice systems are fundamentally changing in the light of digitalization. And Chair, you also referred already to it. The digitalization is a reality today. Starting, of course, by relatively easy tools of let's say, sending documents, but far beyond that, nowadays IT tools are being used much further in terms of analyzing data, in terms of analyzing laws, judgments, in terms of even handling low-value claims, mass claims, etc. So digitalization is a reality. Therefore, to your question, new technologies and core values, potential partners or inevitable mismatch, I would say the starting point clearly is it's happening. Is that good? Is that bad? Well, that's a big question. In my view, there are three drivers that we need to look at when trying to answer that very fundamental question. The first is the efficiency of justice systems. The second is the access, and the third is, I would say, quality of the justice systems. The first in terms of efficiency. It's obvious that IT tools can massively improve the efficiency of justice. Talking about cross-border submission of documents, it may take up to 12 days in Europe. If you want to send a registered document by email, that goes extremely fast. Again, analyzing data, an IT system, an IT tool, a good one, may be much faster than if you ask your legal assistant, your referendaire, whatever, listen, can you do me this kind of analysis? So the potential of IT tools to improve the efficiency of justice is massive. And that's something which is very important because our justice systems are, let's say, under challenge. Already earlier today, we had discussions about the resources in the justice systems. So any potential benefit of IT tools for a better efficiency of justice systems is clearly something we should fully exploit, so they are clearly a partner. In terms of access, the second criteria, again, digitalization has massive opportunities. We saw it in Corona, where citizens could not travel, but were supposed to take part in proceedings, where access was not possible. Digitalization helped us to continue delivering justice. And that is just a reminder that, again, the digitalization has a massive potential there, across border, but also for people that cannot travel for all kind of personal reasons. It's a great potential that we have at the same time. And there we see already that most of the IT tools, of course, have benefits, potential benefits, but also risks. By going too far into digitalization of justice systems procedures, you may lose track of certain elements which are meant to ensure, for example, a fair trial. If you go fully digital, how does that reflect on the fairness of the entire procedure? But also, not everybody may want to decide to go digital. Citizens, in principle, have the right to decide whether they want to go digital or not. Is that the same for procedures, or is it then fully in the hands of a judge to decide? If you have a client who doesn't want to be digital, doesn't feel at ease, can the judge then decide against your client, I want to go fully digital? So on access, clearly a big potential, but already some possible risks in terms of better justice in the future. Third point on quality, there we're coming to the core of the crutch, I would say. Again, good IT tools, AI in particular, of course, has the potential even to improve the quality of the justice that you, together with the other actors in the justice systems, deliver. In terms of analysis of data, mass data, in terms of analysis of laws, also in particular in cross-border situations, analysis of jurisprudence. A good AI tool can do miracles and provide very fast, very reliable information. Can. It may not. That depends on lots of elements that factor into the AI. It also may be, if that analysis puts you on the wrong track, ignore certain key judgments, certain key provisions in the law, then, of course, the quality of the justice that you contribute to deliver will significantly deteriorate. So those are the three drivers which I think we will have to watch together to see whether at the end those new technologies are more a partner or more a mismatch. At the EU level, we are working at different levels. We are working at the question of the legal framework, at the level of building infrastructure, and third, at the level of creating the right environment. First point regarding the legal environment. Obviously, it's critical. Rules on justice systems are there for a good purpose. They are there to ensure a fair trial. They are there to deliver on the fundamental rights, key core values of our legal systems, to which Marija already referred to. So rules are there for good purpose. Therefore, if now we want to tap the potential of the technological tools that we now have, we have to revisit the legal frameworks. We started doing that at the EU level, for example, as regards the service of documents and taking of evidence, where simply we had to provide where is it possible to use electronic communication tools. We are about to complete further legislation, the digitalisation regulation, which will further digitalize 24 additional acts. Most of them, however, at the moment only allowing very specific parts of the procedure to be digital. So no full trial would be fully digitalized. You can do video auditing of an individual witness, for example, if that witness can't travel. But we have not yet gone so far to fully digitalize an entire hearing. That's one question which we then will have to reflect together. Do we want to use those tools only for specific elements, as we do at the moment at EU level, or do we want to go the next step and fully digitalize an entire hearing? And if so, in civil law, company law, criminal law, how far do we want to go? Very important, of course, in terms of building the legal framework is the AI Act, which is being negotiated and which was already discussed in the first panel this morning. Absolutely critical. The Commission's proposal, as you will recall, set out that all applications in the justice system would be high risk, which means, by the way, not banned. In principle, you could, under the AI Act, develop AI in any kind of area of justice systems. That's not the full reality, because the key rules of the Charter on Fundamental Rights, the European Convention on Human Rights, bans AI to our interpretation in certain areas. But the AI Act, as proposed by the Commission, risk-based, would classify all the AI applications in the justice area as high risk. This is being negotiated at the moment in Council and Parliament, and this is one of the elements which is still being discussed. It may be that not all AI applications in the final version of the Act will be high risk. It could be that certain applications will be put low. We will have to see what comes out of it, but this clearly is something we have to watch very carefully because this will have a major impact in particular on the third driver I mentioned before, so on the quality of the justice systems. The second point I only want to mention briefly is the infrastructure. We have, if we want to tap the potential of the IT tools, we have to make sure that the infrastructure is there. That's mainly something for the authorities, where we will have to see together with the member states, where do member states stand, how can we support them, where does it make sense that we build infrastructure at union level, where does it make sense that we build it at national level, and how do we make sure that those systems are interoperable, both on hardware and software. For the private sector, for lawyers, it's more yourself that are looking into this. But again, we need to reflect together what kind of infrastructure is there, what kind of software do you use, where do we want to develop that software, do we want to get engaged, or do we leave this kind of development of hard and software completely to the private sector? If it's exclusively private sector, you come to questions of independence, of again, quality of the tools that you're using. So infrastructure is something which we again have to keep very closely on our radar screen. The third point is creating the right environment. And that relates to questions such as training, but also learning from each other. Training we already discussed this morning. It's absolutely critical, as the Commissioner mentioned already from let's say, early stage on, that in also the studies, when you study law, that this is part of the curriculum at the universities, but of course also for the professionals like you already operating in this practice, that you are trained in using the tools, so that everybody who's operating in the justice system has a knowledge what is going on, has an overview of the tools and learns how to use the tools, also understanding the limits of those tools. But also learning from each other, in my view, is critically important. We have a differentiation of the use of technological tools in the justice system in the member states. Nonetheless, the challenges and the risks are similar, and therefore we would like to try to help member states and the professions in the member states to see who is standing where, that we identify best practices and then can learn from each other. That's why in the Justice Scoreboard that we are doing regularly, we are asking more and more questions about the digitalization and the justice systems, to simply track where are member states standing, then see where are gaps, but also who is leading in which area, and then try to really come to this learning from each other. That brings me already to my conclusions. Back to the question, new technologies more a potential partner or inevitable mismatch? I would say at the moment the jury is out there. Clearly there's a potential for being a very important partner, and it is happening. There is pressure, there's pressure of resources. This will happen for sure. But of course there are also risks out there. So in order to tap the potential which we have in your interest, in the interest of an efficient delivery of justice, but also a good delivery of justice, while avoiding the risks, 3 steps which I think are important to take forward. First is having a precise understanding where do we stand today in terms of use of IT tools. And that's also something Michael O'Flaherty already from the FRA agency mentioned. They're doing a study next year. I know that you have a study from 2 years ago. I would invite you to update this study to understand where are you standing today in use of AI in your different countries and law firms, because the AI Act should be finished by end of this year, more or less. And then we collectively will have to zoom in to try to understand what does that mean for the justice area, and how do we together as justice community want to get engaged in applying the future AI Act. The AI Act will be high level. To be broken down to reality, we will need, for example, standards. So do we want to get engaged in developing those standards? You mentioned also some guidelines already for video conferencing. So we will have to understand where do we want to get engaged. Therefore, let's say having a precise understanding where you stand, I think would be excellent. The second step will be then this common reflection and engagement to make sure that the new framework, such as the AI Act, are then applied in a correct way, correct in the sense of delivering a more efficient, but let's say a solid, fair delivery of the justice systems. And the third point I would like to mention is, at the same time, while implementing the new rules, I think we also should engage into a vision for the longer term. Where do we want to see the legal profession, the justice systems, standing in the year 2030, 2040 in terms of use of technology? What is our longer term vision in terms of the role of the lawyer, the role of the judge, of the prosecutor, of authorities vis-à-vis the technological tools? So those are my suggestions for taking it forward, and now very much looking forward to the discussion.
Thank you very much. You have flagged many issues, many interesting points. Thank you so much for this. You referred to the main drivers of technology. You mentioned quality, you mentioned access, you mentioned also efficiency. We heard also this morning that, and you said it yourself, that efficiency is a massive driver. And one of the concerns that we observe is that it could overshadow the other elements, namely the accessibility and especially also the quality of justice, how to maintain the quality if it's overtaken too much by efficiency. So this is probably something we can discuss later on, but first I would like to give the floor to Thierry, who will give the view from a lawyer's perspective.
Il est 11h56 et je peux donc encore...
It is 11:56, therefore I will start by saying good morning, as I'm the last speaker today in the morning. I shall attempt to answer the question, but of course I will answer on behalf of lawyers and on behalf of their ethical approach. Now, firstly, I would like to try and answer the question, is it the use of technological tools compatible with the objectives of our profession? Now, we are well aware and have been for a number of years that the implementation of new technologies is not neutral. It could actually have some influence on the different stakeholders and therefore on their ethical approach. Now, I'd like to say a few words about what CCBE has been doing so far. Since the beginning of new technologies, of IT, we have promoted a guide on new technologies in 2008. Then in 2012, we had a guide on cloud computing. In 2018, we provided a guide on the use of platforms. And we also mentioned or provided a handbook concerning the differences now in the communication between the client and the lawyer. And following the CCBE work, we have thought about artificial intelligence and the implication of the use of AI in the legal activities. Now, so as far as AI is concerned, we are at the beginning of a thought process. And let me just come back on the main uses of AI for lawyers. Artificial intelligence is a group of manifold tools, but speaking about lawyers in particular, we're talking about most applications, the applications concerning natural language processing. This is certainly at the heart of the use of AI by lawyers. Now, let me explain. In the legal area, it will enable us to better master the contracts, to check inconsistencies between different contracts. It will also enable us to update automatically certain documents in view of the new legislation. We will be dealing with compliance, due diligence, etc. All of this can be made easier thanks to artificial intelligence. Now, from the legal point of view, we know that some case law research can be done in natural languages. This goes much faster. You can also submit to AI the conclusions of the adverse party. And certainly, one can also have an inkling on the results of a court case, and it is even possible to actually transform legal language in a more clear language in order to discuss things with one's client. Generally speaking, you can use AI to draft some form of summary to actually bring together the elements put forward by judges. And this is actually what we are already expected to do in France. So
let's not look at the values that may be impacted by using AI. Let's start with first thing first. What are the core values of the profession, where we've just mentioned it this morning? Independence, secrecy, and then a third element, a very important value but less influenced by AI, conflict of interests. But When we look at AI, we also have to look at two other core values: competence, skills, and then also duty to inform and to counsel the clients. Those are the core values we need to pay attention to. Are they going to be impacted by AI or not for lawyers? Again, CCBE has been working on the matter. There is some base for it with this guide that was published in 2022. Let's not exaggerate here. So 2022, and in this guide, of course, we were already mentioning ChatGPT. It was only version 2. So what is the first duty for a lawyer? The duty to have skills, competence. From the moment in time you're using AI, how is this duty going to evolve? And this is particularly true for smaller offices, law firms, because they will have to use tools that do not belong to those firms. They will be using tools that have been developed by third parties, other companies. For smaller law firms, they could, under some circumstances, develop an offer, and so this could be a major opportunity in terms of access to justice, because we will be able to develop the offer for lawyers. Nevertheless, that comes with a risk. To have an answer for everything. So far, this was not the case. And in that case, his duty of care, in this case, the lawyer had to say, sorry, you have to turn to someone else. But with a tool that has an answer for everything, we could easily have a form of illusion of this duty of care. Think that you're skillful when you're actually not, when you're not able to check the results of the tool. And in this field, there will be a major impact, but the duty of care in itself will need a new definition. This duty of care exists and is mentioned in the deontology rules fixed by CCBE, and it will have to evolve. Why? Because we'll need to add another layer to it. We'll have to train everyone. Yes, indeed, there will be this duty. And then also a duty of surveillance. We'll need to have an answer from a lawyer, also when he's using a tool of AI, but he will also have the ability to monitor, to exert its surveillance on the answer of this AI. So we will need a new definition of this duty of care. Now, in terms of counseling and information, CCBE requested this when addressing a judge. If you use AI, you'll have to tell us every single time. And your ruling has to say this is an answer provided by an AI tool. And of course, will be submitted to the same obligation towards our client. If we use an AI tool, the client must be informed. And then, professional secrecy. And for this point, it's not so much about AI, but rather its implementation. As I've said, smaller law firms will have to use external services. And when that's the case, especially when it's about a professional and a legal service, this matter touches upon the question of professional secrecy. Before, this was done within the offices of a law firm, but in this case this will be outside. And so we will be submitted to some extra obligations. Firstly, we'll have to transfer data, so there will be a need for encryption, end-to-end encryption. Then this external service provider will not be allowed to use and exploit data. However, we know that data is actually what feeds those AI tools. So there will be this urge or this willingness for this external service provider to use data. Then, how will these secrets, those confidential matters, will be protected? Maybe it will be very easy for some parties to look for this information. And then, to conclude, how can we, or how can a smaller law firm control the efficiency or the ability for this third party to respect this legal professional privilege? So for professional secrecy, two major challenges, and this is actually the last point I would like to highlight. There is a real question about independence. From an intellectual point of view, the fact of giving our services to an AI tool is already a backlash in terms of independence. But apparently this will become more and more necessary. But just the fact that we could become a monitoring body, this will also already represent a backlash in terms of independence, because we will be facing major challenges. And then there is another problem, I've already mentioned it. In our profession and its guiding principles, and this is at the heart of our profession, there is the possibility of justify the answer he is giving. But when we are not able to give this reason, this also represents a major issue in terms of independence. And then the profession of lawyer is going to be confronted to economic operators who will be very powerful, more powerful than smaller law firms. And so there will be an asymmetric position, relationships, because of the availability of those AI tools. So this represents a major challenge for law firms in order to guarantee that data from lawyers won't be used. How can we have guarantees about the fact that data can be recuperated by a lawyer? How can we make sure that those AI tools are not going to impact negatively independence? Thank you.
You very precisely indicated the issues arising for lawyers when they start using AI tools. Thank you for that. You particularly referred also to the competence issues which arise when lawyers use those tools in proper a way that they are not fully aware of the biases included in the tools they use, etc. However, there is also the issue of the competence of actually the AI tools themselves, especially when they are used without lawyers. So that is probably also something to consider when tools are brought on the market, which probably already exist, and they are being used without a lawyer. We have not such oversight, so a lawyer is obliged, has deontological rules of competence, etc., to respect. But those rules do not exist yet for the AI tools that are brought on the market. So that is probably also an issue that has to be tackled in some way or another through legislation. Before giving also the floor, the audience, the opportunity to ask questions, I wanted to also ask one question to the panelists, and maybe starting with you, Marija, because there is so much said about biases in algorithms. It's really, when people talk about AI tools, this is often one of the first things that is being raised. And the question is then, how can the European institution address this problem? And because, of course, it needs to be properly ensured that there is no bias, especially when they are used in issues such as predictive policing or sentencing. Is there something the Council of Europe has done or is planning to do on that?
Thank you very much. Let me make one general comment which transpires from what we heard from, I think, all of us here, is that there are more questions than answers. And there is a clear need for regulation in the field, and I think therefore it's very important that we will have Digital AI Act, hopefully soon to be adopted, and then the Convention of the Council of Europe in next year. So, but coming back to your question, so when we speak about automated legal process, I think it's very important what we mean by that, and whether we really want that as an end result. I'm not sure from what I heard. And personally, I'm not convinced that we need that. I would rather say that from what we know now, it seems that we need to use all what is possible to be used as a support to what we do. And I think a lot of what you explained is going into that end, but not to replace. And I think there is this big danger. But as one would say, the devil is in detail. So while going on that road of development, certainly we need to have that. So regulation will help there. So if there is a question on whether something which we could call fully automated legal process would violate the right to fair trial, I would say certainly that would be the case if we take what is guaranteed by the European Convention on Human Rights. I'm sure that we need to take into consideration what we want as the end result and how we are getting there all the way through. Secondly, I think I need to again come back to the fact that there could be bias and discrimination, and from what we've seen so far, the artificial intelligence is prone to amplify the discrimination when it exists. So there is a big work to be done there, and I think we need to be very careful. A new study that we, Council of Europe, had on a more horizontal basis, not only linked with judiciary, but including judiciary, shows that where there is a stereotyping, the AI reproduce it and amplify it, and where there are false assumptions about gender, race, or sexual orientation, this is also the case. But we also observe in the study that was recently published that the risk of automatization bias, even when used as a support tool, may be there. So we need to be very careful on approaching this. From what especially Thierry, you have described from the point of view of a legal professional, of a lawyer, I think there might be a very big attraction to ease the work in many ways. And legitimate, there is a legitimate need to do so. But while doing so, I think one should never underestimate and forget that there should always be an overseeing mechanism and control somewhere along the process. And that whatever the end result of automated process would be that the professional would need to check against all standards which are important. So that comes with the three important, I think, conclusions. One, the regulation is important. Second, the training and awareness raising is important, and certainly the more transparency when it comes to algorithms and the systems that we use. But you mentioned the predicative policing or algorithm sentencing. Probably these are the areas where one should think of ban. Of use of AI. I mean, I open the floor for that, but it seems that if we use, for instance, predicative policing, which is actually counting statistically whether someone can commit or would commit, I don't think, unless you link it with the individual concerned, that you can really sentence a person based on that. So this is why I think that at least at this stage, how the things look like, probably we shouldn't go that far. And the same go for algorithms. So the goal is how do we control the algorithms? Thank you.
Yeah, this is probably also...
Yes, thanks a lot. Fully subscribe to all what Marija just said. But indeed, let's say, what can we do from a regulatory point of view? Of course, if you ban, then you have a clear situation. But the ban will only happen in very specific exceptional cases, like real-time monitoring of biometric recognition in public places, for example, unless there is a very specific exceptional situation. So for certain areas, you can come to a ban. But at the same time, of course, the potential of AI is very important. And therefore, the AI Act will not ban, for example, AI in the area of justice systems more generally. The question is precisely what you also referred to. Of course, the willingness is that the human being, the lawyer, the prosecutor, the judge, takes full responsibility, but supportive functions can be done by the AI. In principle, a good idea. Again, let's say if you have a good AI system, that a good AI system will deliver you a better analysis of the facts, of jurisprudence, of laws than your legal assistant, unless the legal assistant is absolutely outstanding. If you have a bad AI, then let's say it looks totally different. But therefore, the AI Act, we will have to see the final outcome of Council and Parliament, but very probably will not ban AI in justice systems overall, but will come to a case by case. And that's why you don't have a single bullet. You don't have the silver bullet. There is no easy solution. The proposal of the AI Act is, let's say, as at least for high-risk applications, you have all kind of obligations in terms of designing the system, meaning what kind of data do you use? It's absolutely critical to decide what data. Then what is the algorithm which you're using? So again, design obligations, transparency obligations, reporting obligations, and human oversight obligations. So all that in principle is well meant, but to apply that in reality requires that really the justice community gets involved then in making sure that this system applies correctly and is indeed controlled, as you said, because even if the rules in the AI Act are good and solid, that does not mean that it trickles down correctly into the reality. So I think we simply have to put our hands into the mud, and also we as justice community, we were not used, for example, in being involved in the development of standards in the technological area. We have to, because the standards will determine the contents of the justice. Therefore, no easy answer, probably not a black and white decision at the end of the AI Act, apart from very few applications. The rest will be grey zone. In order to make sure that in the grey zone we come out correctly, we really have to get fully engaged.
Thank you for that. And that brings us maybe to the perspective also from a lawyer when an AI tool would be used in the decision-making process. I mean, we could imagine that judges at some stage will be interested to use generative AI tools also to assist them in decision-making, in the drafting of a sentence. What would be the issues arising then for the parties in the trial?
Well, It's not science fiction. Just takes Annex 3 of the AI Act and take the definitions given by this act regarding the use of AI in justice to assist the judge in applying the law. And I believe this is the very definition of judging. And so you can imagine, and by the way, the judge cannot forget that according to the AI Act, he becomes a user with obligations he has to comply with. And I'm not convinced that our jurisdictions today are able to face such obligations, but that was just a side comment. Now, imagine for a minute that the judge uses, during the deliberations, an AI tool. Now, if I were to try to define the current mechanism of a deliberation, how does it happen? Well, this happens after a contradictory debate. And usually, in most systems, the judge will favor one or the other solutions that were put forward by the lawyers of the parties. When the judges wants to opt for another solution, usually there will have to be another debate, or he might not be able to. So that's the first part. The ruling is given on the basis of what the parties have presented and what they have debated. If the judge uses an AI tool and that this AI tool gives him a third option, well, that's it. We won't have a contradictory debate anymore. So I believe that this is the first challenge we're dealing with. How can we reconcile this contradictory aspect with the mechanism of judging itself, which is really at the core of our entire legal system? Then there are other topics that we could also address. We've talked about bias. Judges, in any case, are trained to fight their own biases, and this is not the case for machines. The judge, as a user, will be responsible for the machine's biases. However, this might not be an ideal solution. And of course, I cannot resist to give you this statistic. When you've been called to a French court, what is the best day to be judged? And according to the polls that were made through AIs, apparently it's the day of your birthday, because you will get a 3% discount on the sentence. So just bear that in mind, it might come in handy. So the third aspect that's interesting is that the AI explains why this such a ruling was issued. And so this is important for the acceptability of the decision. The judge needs to explain. However, if the judge just said, well, the machine decided so, I'm not sure that such an explanation would be satisfactory. And in democratic systems, usually it's up to the judge to make this decision. And so this poses a fourth problem. These are the difficulties the CCBE already identified a couple of years ago in its works, and I believe this is what we'll be facing in the future.
And I remember when we developed those thoughts, it was all very theoretical still, but now we see that it becomes very alive. So then I would like to give the floor, the audience, the opportunity. I see James McGill, former CCBE president, who is keen to take a question.
It's sort of ironic that I'm being hidden from the panel by a computer screen. The question comes from a very narrow base. I'm primarily a criminal defence practitioner. And we find now that in many, many cases, the bulk of the evidence is electronically generated, therefore electronically searchable, and that the material provided by the state isn't necessarily always reliable. So the defence need to have their own AI solutions and typically AI experts. And for the time being, at least in my jurisdiction, legal aid will pay for that, but grudgingly so, and it's becoming increasingly expensive. And I'm wondering, do the panel have any information as to at what level is it being considered to bring in another procedural safeguard similar to interpretation and translation to impose an obligation on a prosecuting authority to make available to a court and to a party the means to avail of the necessary artificial intelligence? Because like anyone in the room who does criminal law cases will see that the amount of material that we now find, much of which is really pertinent to the issue of guilt or innocence, it can only be managed with proper intelligence. And it has to be available throughout the currency of the trial, because the trial is a dynamic thing and things change.
Yes, thank you, James. And this is exactly something we have been indeed concerned about, is the equality of arms, the availability of tools. And this is actually something we also identified when we did the AI for Lawyers project, that we saw that the availability of AI tools is not always there, and you have a danger of a digital divide within the profession. You have maybe a situation where certain bigger firms have more means to invest in these tools or to have access to these tools than smaller firms, but also, of course, across the professions. As mentioned by James, prosecution having certain tools which then the defense is not able to use. Have you any thoughts on that?
Perhaps if I can briefly jump in. Excellent question. We are not digging into this at the moment in terms of developing the legal framework. First, let's say we make sure that the mechanics can take care of the digitalization, so exchange of documents, etc. Second step is building the more horizontal framework, in particular the AI Act. But the third step will be seeing what kind of gaps remain after the AI Act is adopted. And your question falls precisely into this third category, because we first have to understand how far is AI indeed kicking in criminal proceedings, and to the extent that this legally is allowed in criminal proceedings, does that then impact the fairness of the trial, equality of arms, etc.? If this were the case, then indeed we will come with a further initiative on, let's say, responding to the use of AI in the justice systems. This is one of the questions, but to get there, we first need to understand what is the outcome of the AI Act, because it will influence to what extent the use of AI is allowed. And by the way, in follow-up to your very valid points, also to understand how much are you as lawyers using AI? How much are you using generative AI to submit documents to the court? You are also an independent organ of justice systems. Also, that is a point to be taken into account. Then, indeed, as part of this stock taking, we would like to see how far is it being used, and then we will come to that question. Therefore, not at the moment, but it's on our radar screen.
Yeah, just adding one sentence. I don't have an answer to your question, but I can inform you that la CPEJ, that was referred to in some of the introductory speeches, it's going to deal with this issue in have as a priority in next 2 years. So I hope that the excellent minds that are there would come up with some good proposals. But what is clear that you're right that equality of arms is not there at the moment. Thank you.
Yes, please.
Merci beaucoup. Je suis
Thank you very much, Mathias Guillaumard, judge at the European Court of Human Rights, representing France. I'd like to thank the speakers. You talked about the judge, and as judge, I wanted to react to what you said on three things you said. So, first of all, this is a considerable development. At the beginning, when it came to databases and AI, everything was done internally within the institutions, be it for law firms or institutions. And this was really well set up. And now we have these external service providers, and then there's the issue of dependency. And there is the question of the goal. When a jurisdiction creates its own tools, it's to support its own work. However, when an external service provider does this, it's to benefit from this, to get a profit. And so this is something we need to bear in mind. There is the marketing of the legal data, and it's seen as a merchandise, and we need to use these tools bearing this in mind. So that was my first point. My second point now. You talked about the use of regulation by various players, the lawyers, the judges of these new tools. Now, I would just like to add something about this. There is also the risk of substitution of AI. If AI becomes very performing, then tomorrow we will no longer need lawyers, and the day after we will no longer need judges, and that would be a nightmare. Now, we're among lawyers and legal experts here. We all know what we're talking about, but more seriously, I wanted to say that this would be a nightmare for the rule of law, for guaranteeing the rights, and for the idea we have of a human society that lives thanks to law and that solves conflicts also thanks to law. And then third aspect, don't want to hog the mic. This really challenges us legal experts. We need to demonstrate, we need to show, rather, we need to renew our added value. That doesn't mean we should not use AI, because AI will stop using us before that. So we really need to use AI. We need to benefit from it, but we also need to show what added value we can bring on top of AI. I think that's absolutely considerable, and this is something we need to do together. And perhaps what we need to demonstrate is that AI, by nature, is an instrument that basically takes all the data and shows you all the information. For example, this case law shows you that you have X chances of success. What makes justice, and which is in the hands of lawyers when they defend the case, and in the hands of the judges when they issue a ruling, is the fact that there is a fact that you and us, lawyers and judges, need to have a ruling which is not necessarily the same as what was shown in the case law. And this is the issue we have to solve in the future.
Three indeed very interesting comments. Are there any views on that? Yes, please, Thierry.
Juste.
I'd just like to circle back to your last remark. I think what will, quote unquote, protect us, because I think we've all agreed that we're in the presence of lawyers and magistrates, but that is what will protect us is the uncertain nature of law. We all know really very well that today we are applying and referring to texts and legislations which were drafted hundreds of years ago. And this is because neither of us react in the same way. However, the machine will never react in this way. It will never refer to old text to solve current problems, but that to a certain level. However, there are many disputes where such philosophical questions are not even asked. And what we can fear is that we have a two-geared legal system with, on the one hand, a machine which gives you a ticket and it will give you your answer for your court case. And on the other hand, if you have a more serious case, then you might go to a court room.
Question? Yes, please. Guido.
Guido Imfeld from the German delegation to the CCBE. I would like to ask a question, or I wonder myself, if being on the sideline and coping with this problem, we raised biases, data used, algorithms always changing, if being on the sideline and trying to cope with this by regulation is enough. All this AI business is clearly profit and efficiency driven, which is normal. I don't criticize this, but the investors will take these two criteria and not the professional rules, perhaps also professional rules. And we will see, so tools we cannot analyze ourselves. We don't know what's in it. There's who needs to know and who is in the need to know, not ourselves, our profession. So meaning, I wonder, and this is the question, if the legal profession, especially the CCBE, and the European institutions which would like to put a framework on it, have not interest in developing themselves such tools. We are 1 million lawyers. No, I don't want to use the CCBE itself as a tool. don't be worried. But we could be a trigger. We are 1 million lawyers, and our tool, if we would develop such a tool, could guarantee that it copes and respects the professional rules and be another actor on the market of AI.
Yes, I think that there was also in the CCBE this project on providing certificates for AI tools. I think that's something that is going on in at least in the CCBE. But I don't know, Thierry, was there not also something in France done by the bar for AI tools?
Oui, tout à fait.
Yes, absolutely. The French bar is fortunate to have set up a company which is specialized in AI. It's called Jury Predis, and this company provides a tool whose quality is just as good as the other tools on the market, and this tool allows lawyers to do a certain number of operations, for example, researching case law, in conditions that are compliant with secrecy, for example. And just to conclude, I'd like to highlight the fact that on this market in France, we have 3 companies, and 2 out of these 3 companies, 2 of these, they were private companies. They've been bought off by 2 larger companies who have decided to invest extensive financial means in them. And so this is also an issue we need to solve, at least at European level, if we want to move forward.
To your question, is it enough to go for the legislative framework? Absolutely no. Is it better that, let's say, we from the justice community develop our own tools? It's an open question, I would say. We can give it a try, and it's interesting to hear that that is happening in France. The question, of course, is will we be able to compete in the longer term? Because it requires massive investment and, of course, massive data, massive learning. You have to invest, and let's say it will happen. People out there will use AI, including in the judicial area. Lawyers will use it, judges will use it. At the end, let's say, if you read the document, you do not know, was it really drafted by the lawyer, by the judge, was it drafted by an AI? You will not see it from the paper, so it will happen. And therefore, the question is, how do we better achieve the desired result of better justice by really overseeing then the process how economic operators, knowing that they pursue an economic interest, but overseeing the process how economic operators develop and update a tool, or rather developing the tool ourselves. For me, again, the jury is open. I'm not too optimistic that, let's say, from a public angle, we will be able to invest and maintain the tool sufficiently. But nonetheless, it's not enough to believe in legislation. We have to get involved, but possibly more in really overseeing how economic operators, big ones, develop the tool, apply it in reality, rather than developing the tools ourselves.
Thank you very much. Just to protect a little bit the virtue of regulation. You know what we are doing at this moment when negotiating the convention. We are including everyone from around the globe who matters in this industry, and whether we like it or not, this is one of the most globalized industry, the IT, that exists. And unfortunately for us who are sitting here, European institution included, the excellence is still with those who are not so much in Europe. So while we wait for possibly having some investment or having some result in medium term, I think it is important that when negotiating this convention, we have at the table the big actors, not only big countries that have big actors seated in their jurisdiction, but also the actors themselves. So at least to limit, the possible problems that unregulated artificial intelligence development would bring. So I think, while thinking of what we can do more on the level of Europe, all actors included. I think the regulation on the global level is important, because our view was, if we do it only by us, Europeans, and we see it clearly while negotiating, I cannot go into details for clear reasons, but it's clear that European actors have one more or less similar concerns while compared to other either political or legal traditions which are hubs to many of those companies, is different. But still, I think there is a virtue of finding a compromise. There is a virtue to have a convention that would apply more globally, but at the same time not forgetting that in Europe we are always ahead, including in implementation. We have the European Convention on Human Rights, we have the European Court, and no one else has it around the globe. And sometimes that also poses a problem for us, because we have higher standards, but for right reasons. So I think that goes the same for the Convention on Artificial Intelligence, with all the shortcomings that we can see, because we need to have a compromise if we want to get this convention. But I think there is a virtue of having a convention, but at the same time thinking, and I think what European Union is doing with the AI Act is clear, but we need to work on all fronts, because the technology is developing so quickly, unlike any other that we knew before. Thank you.
I think I would give the panelists still one opportunity to say some final key point you wish to share with the audience, and then we can conclude the session. No? No key point? I will do it.
Perhaps from my side, 2 points. One is, first, of course, we need to fight that the core of the justice functions are done by human beings. For me, that's an absolutely essential point, be it for lawyers, be it for judges, for prosecutors. That has to be the responsibility for what you're submitting to court. The responsibility, what a court decides, has to be done by a human being. That's the most important point, irrespective of how the framework, the legal frameworks at the Council of Europe, at EU level, will evolve. The second point is, at the same time, I think we should not see those technological developments only too negatively. We often focus on risks, but there is a big potential which can help, as long as the key function is preserved to human beings. Then the support is really something where the IT tools, AI in particular, can provide outstanding support, and that's something which I think we really proactively have to use. But again, it's nothing that will happen by itself innocently. There are economic actors, they have commercial interests. So if we want to deliver on both, preserving the human responsibility for the core of our justice systems, while at the same time delivering on the benefits which are out there, we really have to get involved very closely.
I think I made a point on the virtue of the new convention, but I think equally, because it was raised how much at this very moment the legal professionals are up to the challenges. I think we all should not, there is a strategic work long-term, medium-term, but there are things to be done right now. So I think we didn't have time to develop the training and continuous training I think that we need, starting also with what you mentioned, Nils, with changing the curricula to make it more updated to what the needs of the future market or future profession is, but also to work with judges, because there was a question how much we know, how much the judges could know, how any one of us sitting here could know about these algorithms and technology. And of course, we cannot expect judges to become electronic engineers, and they should not be developing in that way. However, we need to raise knowledge and skills, and at the Council of Europe we are trying to do that. We have help courses, which is abbreviation for human rights, for legal legal professionals. And there is one course that is actually in making, which is targeting artificial intelligence, and it's provided for all legal professions around our 46 member states, but also thinking how the overall knowledge and awareness is there, not only by the legal professionals, but by the clients, by the citizens in general. So we also have a conference on the cyber justice in November, which aims also to gather these first people who are interested in that, and also to share information. And also coming back to CCBE, which has been rightly, I think, mentioned so many times, because is there to help legal professionals in all new aspects that are raised. CCBE has this cyber justice network, which actually is very, very useful as a forum for exchange of best practices and knowledges. You mentioned quite a lot on French, where the France is. I'm sure the other countries may have also some interesting information to share. So I think we need to scale up the skills and knowledge we have now, but also thinking of a longer term how to develop education and training. Thank you.
Okay, many thanks. So I think, yes, in conclusion, we do share all, I think, the goal that we have to maintain the highest quality of justice, and that we believe it should act as, AI tools can act as facilitators of justice and legal practice, enhancing their efficiency and accessibility, but we have to also guard that they do not replace the essential human elements that underpin also our justice systems. And for this, of course, we have some challenges, because how do we ensure this? But I have heard a few things which I believe are very important, and that is also the collaboration between different professions. It is something we as a CCBE find extremely useful when we have the possibility to also exchange directly with ministries of justice, people from the judges community, prosecutors. I think it is extremely important that these different professions are discussing among them, and also with, of course, the IT people sit around the table, especially when AI tools are considered for being used in court systems. Then also, of course, we have to continue paying proper attention to the ethical issues. Bias, fairness, transparency, accountability are all things to be carefully looked at. And then eventually, which we have heard today, also well-crafted policies and legislation. And we are hopeful by the work that is being done, both the Council of Europe and Commission, very complementary to each other. And we look forward from the CCBE point of view to exchange further with you on this, and I'm sure you will understand that we will critically follow your work, and whenever we believe that the values of the legal professions are at stake, we will, of course, communicate that, but we will do so always constructively. So with these final words, I would like to invite everyone, well, first of all, to thank our panelists and to give them a warm applause. Thank you. And then we have a lunch. And I would like that you pay attention a little bit, because it's not just around the corner here. It is in the ground floor, and you have seen how difficult it is, actually. So, I mean, the room is called Le Sablon des Députés, but before, you are probably all not so familiar here, so there will be guides, and so I really suggest you to follow the guides and to not start improvising your own route, but lunch will be found if you follow the guide. Thank you.